In the family that my grandfather bought from the railroad in 1875, 1878, it makes me feel more connected to my own state because I come over here so often and get to interact with people who are in agriculture often enough that I really feel I have some sense of what's required, what you've invested, what it takes to grow a successful agricultural business, to keep the farm in the family and to be successful. And as I say, the key part of that, as I have come to appreciate, is water. And when I was a young lawyer, I worked on water issues in a very different way. I was a representative as a lawyer for Puget Sound Power and Light Company. And as one of their lawyers, negotiated regularly with Bonneville Power Administration and with the PUDs, as well as with the Vista. But mostly all the utilities, including the PUDs, were on one side of the table and Bonneville was on the other side of the table as we negotiated the Pacific Northwest Coordination Agreement, or PNCA. That's the master agreement that controls the operations of the Columbia River from one end of the state to the other. And that's where I really began to gain an appreciation for the importance of managing that resource in terms of meeting the needs for everything from flood control to drinking water to, of course, agriculture and hydroelectric power. It was an incredibly complicated agreement, as you can imagine. I had to learn a lot of engineering lingo, which I have since forgotten, and like a foreign language that you learn when you're a kid and then you don't use it enough. But it was an incredibly instructive period in my life because it taught me a lot about the importance of the Columbia River and the challenges around proper balancing of that resource. So when I became Attorney General, or actually before I became Attorney General, I wanted to leverage that knowledge, and I did that in part by reaching out to Darrell Olson and the Irrigators Association. Thanks to Darrell and a number of others here, Pat Voss, I learned more. It was another continuing part of my education. I still have a lot more to learn, but thanks to you, Darrell, and Pat, I've been very fortunate to have a better appreciation of the issues. So now here I am as Attorney General, and I want to share with you some conclusions I've reached about water and its management, and also a couple of updates on important legal cases that are in the works that you've heard of and you may already be up to speed on, but I want to talk about those as well. The first thing I want to tell you that I've learned based on my own experience is that organizations like the Irrigators Association, but especially the Columbia Snake River Irrigators Association, are very, very important to the wise management of the water resource in eastern Washington and in this area, but moreover I think are really vital to our state economy. Unfortunately, many on the west side don't fully grasp, or may not grasp at all, the centrality of the agricultural sector to our state. They may not appreciate what a big part of our economy is, that in many ways, by many measurements, it is the biggest part of our state economy, and that therefore they don't understand why you care so much about water, because it's so instrumental to your success as part of our state economy. Secondly, I think the Irrigators Association is crucial because you have been, you as members as well as the association, have been trailblazers, leaders in developing conservation techniques and the wise use of the water resource. There is so much knowledge and experience and technical expertise that you have built up over decades and generations of hard work and critical thinking. That we would not be where we are today. We would not be as productive, our state would not be as successful if it were not for that expertise and knowledge. And so one of the conclusions I've reached is that a sound leadership strategy for Washington state water policy is no different than the leadership direction required for other key parts of state government and resource management, which is to say it has to be based on accurate information, expertise, technical capabilities, and should be aiming for the rapid optimization of economic benefits and cost-effective resource development and allocation. That approach to managing resources wisely, cost-effectively, conserving the resource but using it effectively, also has to be coupled with a government that does the right things and doesn't get in the way too much, which is not what I would say is a description of the status quo. It's where we need to head. I think that optimization of the economic benefits of water and of our ag sector using that water need to be coupled with a restructuring of our government's delivery system and retreat from inefficient administrative processes and regulation. And I think that's where we find ourselves today. I think we have an overly complicated, overly expensive system with too little certainty, and I don't think we're achieving the goals of optimizing the resources that we ought to be. And I'm going to give an example of where I think we have made a little bit of progress, which I think points the way to a more optimal use of this resource. I also think that the strategy for water policy in our state must be set up to incentivize private conservation within long-standing water rights allocations and the structure of water rights, such as the Conservation O&M project, which is being implemented by the Irrigators Association. Private sector conservation allows new irrigation development, which I think is the standard that we ought to be emulating, because you have the right incentive structures and you have the right knowledge. You know what optimal conservation looks like. What the state needs to do is to avoid penalizing you for doing the right thing. And that's what I worry can happen and is happening to some extent. That is one of the reasons I wanted to talk a little bit about two legal issues, but I want to start with the Columbia River program, which I know you and your members had quite a bit to do with. As you recall, it was in 2006 that the legislature adopted, thanks to leadership, by the way, from Bruce Chandler and Jim Honeyford and some great legislators from Eastern Washington, a program that will continue to be successful, I think, thanks to the addition of great new legislators like Terry Nealey, who's here with us today. But you, because of your own expertise and your patience and your hard work in Olympia with your legislative allies, the legislature passed the Columbia River Basin Water Supply Law, which declares that a Columbia River Basin water supply development program is needed, and it directs the Department of Ecology to aggressively pursue the development of water supplies to benefit both in-stream and out-of-stream uses. And of course, one major component of this program is the Lake Roosevelt Incremental Storage Releases Project, or the Lake FDR drawdown. This drawdown involves the release of 132,000 acre-feet per year over the Grand Coulee Dam to enable new water supplies for in-stream flows, for irrigation, and municipal water supply purposes in central and eastern Washington. Ecology has issued secondary use permits authorizing the U.S. Bureau of Reclamation to release water from storage in Lake Roosevelt to provide 30,000 acre-feet a year of water for irrigation in the Odessa sub-area, and releases 52,500 acre-feet a year for water to augment in-stream flows downstream of Grand Coulee Dam, of which about 25,000 acre-feet a year will ultimately enable the issuance of new permits for municipal water supply purposes in the region. I thought this was a bit of work, in fact a very major piece of work that you all did. It was a great example of working together, a compromise. I'm guessing that no one got everything they wanted, but that's a lot of water we're talking about. And we were pretty happy that our office played a role in advising the state agencies and the governor's office in negotiating it. Needless to say, we weren't extremely happy. We're not extremely happy when the Center for Environmental Law and Policy, or CELP, and the Columbia Riverkeeper Group appealed Ecology's decisions to issue the permits to the, and they've appealed to the Pollution Control Hearings Board. They did, of course, withdraw their appeals after the motion to stay the effect of the permits was denied, which we were happy about. But then they filed a lawsuit in federal court alleging that the Bureau of Reclamation has failed to comply with the requirements of NEPA in carrying out its role in association with the drawdown. My client and the East Columbia Basin Irrigation District intervened on the side of the Bureau of Reclamation, and ultimately the federal district court ruled on behalf of the Bureau and the Department of Ecology and held that the Bureau has fully complied with the requirements for environmental review of the project under NEPA. That was a good thing. Not surprisingly, however, and we just learned this this week, CELP and Columbia Riverkeepers have appealed the decision we won in the district court to the Ninth Circuit Court of Appeals. So as often happens with these issues, it isn't over yet. But obviously winning at the district court level is extremely important. And I think it's important for two reasons. Number one, because it shows that we're right on the law. But number two, I think this model is very important. And if this model, this drawdown agreement had been overturned by the courts, or if it's overturned in the future, I think it really makes it much harder to negotiate.